Projektima radim sa I sad ono već oni mene čuju, jel ovo samo pričaju, tako nije ništa bilo dodatno. Pitam vas iz iskustva, ne moram ništa vidjeti. Ajde se smijemo. Hi, can you hear me just to check if you hear the sound?
Yes, I can hear you.
Yes,
I can hear you as well.
Okay, great. My name is Marija Vlajković, so I'm here an assistant professor, and I should be teaching from next Wednesday, but unfortunately, Professor Maja Lukic, she is ill at the moment. She'll be fine, but at the moment, she could not have this lecture today, and then it will be me who will be covering the whole EU aspect, meaning the following three course lectures that we will have. That's Saturday, Wednesday, and I think next Saturday. Am I right? Next Saturday, yeah. So yes, next Saturday. Let me check. Yes, I think we'll have three course lectures dealing with the European Union law. Okay, so if you don't have any questions for the starters, I will just now briefly ask you how well are you familiar with the European Union in general? I did it. You too. I have two colleagues that are present, and I think one she will be coming, another one. Yeah, so I will just be asking them as well. And you, if you want anything, you don't even have to raise your hand. You can just, turn on the mic and tell me. So maybe just to ask you, because I am not familiar with your background knowledge. I know that some of you have finished law faculty and maybe some other social sciences, but just to know if you ever studied European Union law, I think.
Yes.
Yelena, yes, okay.
Yes, I had it on a law faculty as a course, yeah, EU integrations. But also in my work, I'm dealing with that topic, so yeah, I'm familiar.
Okay, then as well, the name of you too, sorry. Una je došla kada. Una, you did.
It was on my first year, and in my work I use a lot of the directive one, but we talked about European Court of Justice, and I'm not so familiar with its work. So I don't.
Okay.
I'm from political science, and we had a political system review, and I think that I'm familiar with the work, and it was my last exam.
Wow, exactly. That will be changed now as well at the Faculty of Law. The problem is the European integration law was in the first year, which is so non-convenient because before studying constitutional law or anything that deals with positive law systems, you deal with EU law, which is a very complicated legal system, meaning that you have to know international law, that you have to know European law in general, and then you should know about the EU law. So what we are going to do in the following year at the Faculty of Law, we're going to reintroduce EU law, not EU integrations law, but the EU law as an obligatory, meaning mandatory course in the third year, in the second semester of third year. And then we're also going to introduce another course, which would be foreign policy of the European Union. And then what you said very conveniently, we're going to introduce another course, which is not mandatory, but for those who want to study it. It's a course, practice of the Court of Justice of the European Union. Because when dealing with the EU accession, which I am dealing with, you have to know the practice of the Court of Justice of the European Union, as you know it for the Council of Europe, the European Court of Human Rights. Who else is here? So we have Ksenia, Alexander. Ksenia, can you hear me? Just to check, because you...
Yes, I can hear you. I am on my way to the faculty, but the traffic is awful.
Okay, no problem.
Professor Ka, Dobardan. I am from Bangladesh. Jobem se Islam.
Okay.
I am graduated from the Bachelor of Business Administration, Major Finance and Banking. I am not in this field. I am trying to learn about law and gender. That's why I admitted.
Okay, so meaning that you're not very familiar with the European Union.
Yes,
That's right.
Yeah.
Okay, that's what I get it. Okay, no problem. So here, what I'm going to start with, just short, like it's an introductory quiz, but it's not really a quiz, just to go through some fundamentals about the European Union, because it will be part of your exam. You have to know the basics of the European Union in order to understand what is the gender policy and gender legislation of the European Union. And what is even more so important is that when we talk about, for example, the Republic of Serbia, that majority of us is part of here and nationals, we need to take into consideration gender legislation of the European Union when dealing with our gender legislation, which is currently not so well standing, as we all know. And maybe you talk about it, about our law on gender equality, which was suspended by the Constitutional Court. That law, for example, was sent prior its entry into force. It was sent to the European Commission, for example, for I would say for an analysis and then for harmonization measures. So that every law that we do, and that is what you know in your line of work, every legislation piece, I mean, from the secondary legislation to the primary legislation in the Republic of Serbia has to be aligned and harmonized with the EU acquis. What is the EU acquis? EU acquis is actually all EU legislation, starting from the treaties all over to directives and regulations. So that's it. But let me first share this introductory quiz that we are all going to take together. I mean, I'm not going to, like in school, ask you to answer the questions. We're just going to go through some questions, which are the basic questions, and which I had the help of ChatGPT, of course, which, you know, this is completely normal in the line of work that we do today. Really, I asked ChatGPT what would be the most general questions the students of master studies should know about the EU. And then I tried to introduce some additional questions. Okay, let me just share with the WebEx. Share. Do we have my paper? Yes. Share. Just a second. Let me see if it can open it. Why is it opening? Start from an open. Oh, Lord. Hey, I'm gonna go again just to see why is it so slow. Sorry. In the previous, da li na prethodnim časovima su radile, samo znam PowerPoint prezentacije i sve ostalo, yes.
Isto to mi je protective use, tako da je to nas.
Ajde, sad ćemo da vidimo.
Da li je...
Why is it? Baš je zaštićeno, skinula sam, bukvalno sam ga kopirala sa neta. Sad ćemo da vidimo. Ajmo downloads. Sad ćemo da imamo open with. Nemam dodatak. Sekund. Evo ga. Ima samo open. Let me just check. Sorry, we just need a few seconds to open the Word document. If it's not possible, then we're going. There you go. So these are just basic questions. I know you know them, most of you, and most of the questions are very basic, and I'm going to open them right now. Vi vidite vas sve? Ok, sad ćemo da ga zoomiramo. Ću vam da otvorim na drugom kompu. Okay, do you see the quiz now that is shared on the screen?
Yes.
Yes, we see it.
Okay, so let me just start with the beginning. So the European Union, this was actually not the correct question. It should be the European communities, because the European Union was founded by the European communities. And what would you say is the answer to the first question? If anybody knows, probably C. Great. So I again have the correct answer here. So C is, and we will see why, to facilitate economic collaboration between member states. And then anybody who has been with me at, had practical courses with me at the Faculty of Law knows why. And then it started with 6 countries, right? And how many countries are currently members of the European Union? 27, that's good. Then let's start. Let's start with the official EU institutions. Okay, I'll start now. I'll give the words to somebody who is online. Okay, which of these are official EU institutions? So not European, but of the European Union.
European Commission and European Parliament.
Right. Okay, and then this is actually my favorite question, this EU flag. What does 12 stars represent? Do you know? Probably people always think that those are the number of member states.
Maybe the first states that signed the Maastricht contract, like the first ones.
People usually think that is the case, but those were not 12 stars. Yes, unity and harmony, because 12, as you know, is the biblical number that represents unity, good, and harmony. And that was used in Roman history as a harmonious number that shows kind of equal and equality, representation and equality. So that is actually, this is very symbolical. But this is kind of a common question that usually people think that 12 states were the founding states, member states, or the states that founded after all the European Union. But no, those were 6 states, and afterwards it was 9 states, and then we had 12. So then we start with the EU law. So this is important. The 5th question is, how does the EU law apply? You can answer multiple answers. You can give me multiple answers here. So the EU law, does it apply in all EU member states? And does it have primacy over national law? And does it include, and what is here, treaties, regulations, directives, and decisions?
D.
D, and what else? B. NA. Okay, so this is kind of what we're going to deal with today. I don't know who said it, maybe Yelena or somebody else. It includes treaties, regulations, directives, and decisions, which is completely true. And then the B part has primacy over national law in EU competencies. it depends in which EU competence, because EU has three types of competences. It has a competence where the EU has complete primacy. Then it has a second competence where it shares it with member states. And the third one is just a subordinate competence, meaning it just fills in the gaps and blanks that member states do not deal with. And then for the A, it applies in all EU member states. This is also very important because some of the EU laws and regulations are applied in all EU member states. But there are some EU law pieces of documents that are not applied in all member states. For example, a decision. A decision could be brought only against or for one member state, one or several. I'll give you one that you can remember, but like it's very easy to remember. During the migration crisis in 2014 up to 2016, there were some EU member states that were very much against the migration quotas. If you remember, do you know which states in the European Union were against migrations, accepting refugees and asylum seekers, not now with the Ukrainian part, but in 2014 and 15? Hungary, yes, and Poland. Yes, and what other?
Germany at one point.
And what point was Germany, but then it wasn't. And then do you know maybe Hungary and Poland are complete? Those are the two main states. And then Croatia was actually for a different part. Croatia was for torture on the border. So it was different for migrants and torture on the border. But those countries which were not accepting at all at one point, so the Germany initiated that EU should accept asylum seekers and refugees from Syria, Afghanistan, and all countries that were infected or afflicted by war or other crimes. And those countries that were named the Visegrad Group, meaning the Hungary, Poland, Slovakia, and Czech Republic, were the countries that did not initially wanted to accept, I would say, any migration legislation. So there was again a case before the European Court of Justice, and at the end there was a decision that was brought and that actually tackled only those four countries. So that's why, if you want to remember, does the EU law applies in all member states? Generally, yes. You would always answer yes, it applies when we talk about the treaties, when we talk about other pieces of legislation, but it's not the case in 100% of cases, because there are some EU documents, EU pieces of legislation that applies only to selected member states. And those are the decisions. That's always the case with decisions. Rarely a decision is directed towards all member states. I will now give you an example when the decision is directed to all member states. Again, from practice, you would always know the case of Russia and Ukraine, and sanctions against Russia are renewed every 6 months, as you know, by European Union. And when they are renewed, not removed, they're actually enforcing them, not removing them. When they're renewed, they are renewed by the Council decision. And this decision is actually applied in all member states. How will you know the difference? Because in every decision, it is very directly stated to which countries is decision applying to. And that is very easy to see. Is it in all member states or just particular member states regarding the particular case? Okay, so we go further to the gender equality part. What does it mean to have gender equality in the EU? What do you think? It could be one answer, it could be all answers. You can say, but is there anybody online who wants to say anything?
I'm guessing it was probably employment and equal pay first.
Yes, that's right. And then, are there any other parts of this? Other answers that could also fit into gender equality in the EU?
Well, I hope so.
I hope so. Me too. I have my colleagues here who said also C, meaning that the EU promotes equality in all activities. And this is actually called how? Mainstreaming, right? And that is also part of the EU obligations that it should do. And then what else do we have here? Okay, B is definitely not correct. Only women's rights are protected. Why is this here? Because there were some EU Court of Justice cases where women were given preferential treatment without, I would say, objective reasons. That's why there were cases where without having an objective reason, women were given preferential treatment, even though the whole EU non-discrimination legislation was built upon the cases where women should have the same rights, but we will deal with it later. And then, does it apply only in the workplace? Yes, originally, as we all knew, it was applied only in the workplace. And I'll tell you which country initiated actually for the first notion of the EU equality to be introduced. Do you know which country maybe? There were 6 member states at the beginning. So it was France, it was Germany, Luxembourg, Netherlands, and Belgium, and Italy. Which country do you think introduced for the first time, or actually initiated the introduction of the equality and gender equality in the workplace?
Maybe Germany.
You are all not correct. It was France, actually, because France had the first, I would say, national legislation among those 6 states. So France was the one among those 6 founding member states that had legislation that actually dealt with gender equality, meaning equal work, equal pay. And then France didn't want other countries to give, I would say, less or preferential treatment to men, because what would they do? So all men from France would go to other states to work. So there was, again, an economic motivation there, not really like a true motivation. Let's give women equal, or I would say non-discriminatory position. But it was, okay, we give women and men the same pay, but maybe if other countries give better pay to men, then our men will go to Belgium or they'll go to Netherlands. So what we are going to do, we are going to ask that all member states, meaning those 6 countries, which were all neighboring countries, we're going to ask them to introduce the same rules, equal work for equal pay. So, yeah.
That's like also similar with the Germany social.
Yes. So it's always, here also was in bottom line social reasons like social justice and fairness was also what France said, but I think it was for purely economical reasons why France introduced this. And so you probably know the answer for number 7. So it's, why the EU originally promoted gender equality. We talked about it, it's employment and equal pay. And then do you know maybe between these, okay, D is definitely not the answer, between education and family law, do you know which was the most progressive after employment and equal pay? What do you think?
Progressive family law.
Family law. Okay. It depends. Different states had different pieces of legislation which were introduced. But in the EU, it was first the education policy. Because why? Because it was related to work and employment. Meaning if you give women, or in any case, if you give women equal opportunity to not only school, but for the specialization and other, I would say, qualification gathering, then you will also improve the employment rate and then equality while employed. So after the education policy, then comes the family law. When we talk about the family law and equality, what we talk about mostly, it's again related to work. Maternal leave, firstly. Secondly, when you work half time, then the salary if you work half time, then everything else that is related again to being a mother more than being a caretaker as another parent is. So again, everything which was done in the European Union was related to employment and equal pay. And this is maybe the most important part that you should remember about the history of the European Union, that in the first 3 or 4 decades, everything that was done in the European Union was done in order to create a single market, meaning it was always with a lucrative economic goal, even though it had very, very good, I would say, outcomes, meaning gender equality, meaning gender mainstream, meaning protection even of human rights, meaning the non-discrimination part related to not only sex, but race, religion, and other forms of non-discrimination. But everything bottom line was in order to create a perfect single market. And what is a single market? Single market is actually something that you have between all those states that are part of the European Union, where you can have 4 freedoms. Which are those 4 freedoms? Do you know maybe? Those 4 freedoms that are basis of single market. Yes.
The freedom of capital, I don't know actually the English.
I'm at the srpskom and I'll translate. Okay, so it's thank you, and it was a correct answer in Serbia, but it's great. So you firstly freedom of goods. Secondly, freedom of people. So not freedom, but I would say free movement of citizens and people. Free movement of citizens. Then thirdly, it's free movement of capital, and fourthly, it's free movement of services. It's all interconnected if you think about it. In order to have free movement of goods, you need to have free movement of people that will move that good. In order to pay for that goods, you need to have free movement of capital, meaning money and banks. And in order to have the free movement of money and banks and everything, you need to have completely liberalized services. And that's it. So everything what was done in the European Union, and that's the one-on-one lesson, it's all done with an economic goal. And then through that, the European Union actually became this union not only of economy goals, but then afterwards human rights and other goals that we will talk about. So we go further below. Now we start with which EU document, so it's number 8, includes a principle of gender equality. What do you think? There are several answers. So is there anyone online who can maybe answer to this question?
I'd say it's probably the Charter of Fundamental Rights and the European Convention on Human Rights.
You're right, but the European Convention of Human Rights is not an EU document, because the European Convention of Human Rights is the Council of Europe document. Why you are not right, but you're halfway right, because this is the fact. All EU member states are actually member states of the Council of Europe. So they're all applying the same piece of document, and that is the European Convention of Human Rights. But it's not created by the EU, therefore no EU institutions cannot impose it. Only European Court of Human Rights can impose it. So this is kind of half true. And then the Treaty on the European Union as well. So this is what you forgot, but that is kind of even more important than the Charter, because the Treaty on the European Union is the fundamental piece of legislation. That's kind of what the EU would like to say. It's a quasi-constitution of the European Union, the treaties. Those are the founding documents of the EU. And when you start actually learning about the EU and analyzing EU legislation, you always start from treaties. And then you go further into the pyramid of charters and directives and regulations, etc. The Schengen Agreement, do you know what it is? Do you know what
it's the agreement for travel between European countries. So it's definitely not that, I could tell.
Yes, it's definitely not that. But interestingly enough, in the Schengen Agreement, it is said that citizens should not be discriminated on any basis. So implicitly, we could say that gender equality is included, but it's not that. It's those two that one that you mentioned and one that I mentioned, actually. It's the Treaty of the European Union, and it is the EU Charter of fundamental rights. So we go number 9. This is maybe kind of not very well known. Which EU body collects data on research? It's the first one, the EU Institute for Gender Equality. And it is where...
Yeah, it seems logical.
Yeah, it was logical. And why do I say this? Because if you ever are going to write something about the European Union in your seminar papers, in your clinics that we will have during this year, you will always find information, meaning the data, the most relevant data, on the website of the European Institute for Gender Equality. So why did I put it here? Because when you don't know the data, meaning how many women, what is the percentage, what are the women, how much women are represented in national bodies, in the courts, in every country, including European candidate countries, meaning Republic of Serbia, all data could be found on the European Institute of Gender Equality. And that's why I put it here, because you would definitely need this website to know it, because it's the most relevant data on the on this topic in general. Okay, so we go more, just we have 3-4 more questions. Gender-based discrimination in the EU. What should be applied to this sentence from these answers here? What do you think?
A and D, maybe?
Okay, the A is definitely, this is prohibited because any kind of discrimination, and we will see what are the foundations for discriminations. A is definitely, so the C is definitely not, I don't know, it's allowed if a company chooses. Do you know why this was? Because there was again a case before the European Court of Justice where it was said, listen to this, in the treaty, so as I told you, the treaty is the founding document, the most important document. In the treaty, it was said that non-discrimination, meaning gender-based discrimination, is prohibited by EU law. And what the companies did, the private companies said, we are private companies. We are not public companies that should respect EU law. We have our own private statutes and documents and other regulations. And if we choose so, if we think that a man is a better candidate, only in the private sphere, we can give him preference. And then it was, I think, in the 80s or in the 90s, we'll see. Kind of end of the 80s. And then the EU court again ruled that not only public institutions, public companies, EU institutions are to respect the treaties and the non-discrimination, but also any other public company, private company, private enterprise, small and medium enterprise, they should all respect the gender-based discrimination prohibition that was laid down in the treaties. And that's why, again, with the Court of Justice of the European Union, this principle was kind of, I would say, deeper down. So we go to the EU single market, which we did. So we will just go to the EU Parliament and EU Parliament. So what is the correct answer to this? There are several answers to this, the EU Parliament.
Located in Strasbourg and Brussels.
This is the easiest, okay?
It's probably responsible for proposing new EU laws.
Yes, so it's A, C, and D. And why do I mention the European Parliament? Because the European Parliament is the one that actually gives the initiatives and impetus with the European Commission for the new piece of legislation that deals with gender equality or gender mainstreaming. And because later on we will see how many women are, or actually what is the gender disparity that exists in the EU institutions. And then finally, in order to introduce what we're going to do today, the principle of equal pay was introduced when? What do you think? This is the question number 13. Let me just...
I think no.
Yes. It was in Rome. It was in 1957. So it is I would say it doesn't exist. The Treaty of Rome, it was in the beginning. I'll explain it to you. But the first principle that dealt with gender equality was actually the principle that was introduced in one of the first treaties, the Treaty of Rome. And number 14, what do you think is the most, I would say, most pressing challenge in the European Union now regarding the gender equality? What do you think? What would be your answer? All of the above. What would be like the most pressing issue for you?
Probably equal political representation.
Because you know that the EU institutions don't really care about anything else. Equal political representation is something that is mostly challenged in the media, but what is in reality the most pressing issue is the violence against women, and that we're going to do together next Saturday when we're going to deal with, and this is my favorite topic, we're going to deal with relations between the EU and the Istanbul Convention. Have you heard about, you dealt with the Istanbul Convention. We are going to actually deal with how the EU implements the principles and standards from the Istanbul Convention in its own legal order. So we are now done with this very, very difficult quiz in order to start this. Sorry, I'm going to I'm going to stop with this and then here. No, not stop with you. Okay. Let me just turn on the PowerPoint presentations. Okay, this is my. We're also going to have a break. Oh, wait, some of the. O Bože, sam ne radim. Mi jeste li vidite, pošto sad... And now I have to maximize, and then I have to share this, share, there you go. Just tell me if you see the presentation, to be sure. Okay?
Yes.
Yes, okay. Okay. Funny. Moram da ih nekako smanjim njih. We go to the next slide. Okay, this is what we are going to try to cover today. And I say try because it's always very pressing with time. I don't know, today we have till 1:30, right? Okay, okay. We're going to do like half an hour more, and then we're going to have a break, and then we're going to do an hour more, okay? Is that all right with you online?
Yes, it is.
Okay, thank you, Yelena. Okay, so today I'm going to cover only the basics, meaning what we did now, what we covered through the quiz, what is the origin of the gender equality principle in the European Union, and then how the gender equality policy actually evolved through the European Union legislation, and then the European Court of Justice. And then we're going to deal with the most boring part, and that is the EU secondary law, which I don't like either. And then we're going to just make like an introduction for the following course. Okay, this is what we covered, but we're going to go through it again so you don't have to learn it, by yourself. Founding treaties, the first treaty where the gender equality was introduced was the Treaty of Rome, as you correctly said so. The first article that mentioned is Article 119, which actually is the first foundation for the gender equality. And it was done, as I already mentioned, for purely economic reasons. And those reasons stayed for the next 3 or more, 4 decades, the main reasons why everything else was introduced in the European Union policy. And this is how the Article 119 was read. Each member state shall, during the first stage, and meaning during the first stage of creating the European communities, ensure and subsequently maintain the application of the principle, and this is the principle, that men and women should receive equal pay for equal work. And that was the principle. So equal pay, equal work, economic rationale. And this is what you mentioned, the social and labor rights. Social and labor rights were, as I said, initiated by the Republic of France, but supported and endorsed by Germany firstly, and then by Belgium. Why by Belgium? Because of this strike. This strike was actually in the factory for ammunition. It happened in 1966. It was a big Belgian factory where 30% of women actually were working and creating ammunition. And they were called machine women. And they actually were paid less than men for, of course, the equal work they were doing. That was not the difference that men were working on the machines, that men were working more. No, they actually wanted to know if they do the same thing for the same amount of time with the same effort, why were they paid less? And it actually started the whole, I would say, line of protests, or what the French or Belgian would say manifestations, which were all around the country. And it was something that actually introduced other piece of legislation in the EU, which we will see. And now I wanted to ask you this. For you, this is kind of a little thing. I hope you all have internet. I know you have it because you're on WebEx online, but you here as well. The assignment for you that will last 2 or 3 minutes, you need to find what happened in the Defren case. So you need to write this Defren case, or you write just Defren and the European Court of Justice. What happened in this case? Does anybody know? Has anybody heard of this case? Probably not. So you can Google it. Really, it's kind of, I want you to know what happened. What was the case? What wanted that woman, which was an air hostess? Yeah, you can Google it now. It was like I want you to Google it and not me retelling you all the time.
From what I've been able to find, it's a case about equal pay, where Ms. Defrene's case led to the EU adopting laws about equal pay in the EU.
Yes, it is true. But what happened to Ms. Defren? What was she doing that she was not, I would guess, not paid?
Even pension earlier than the male colleague.
That as well. Something else happened. She worked in this Sabena, which is Société Anonyme Belge de l'Aviation Aérienne. This is kind of like Air Serbia is today, so, or any other air company. And she was firstly an air hostess. Then she became a chief of staff in the plane, meaning the chief air hostess. But for years and years, she received, I would say, salary that was less and less paid. She was less paid than her male colleagues that not only had the same position as she did, but they were underneath her, meaning that she was the chief air hostess and they were just how we say air host. Yeah, she's an air hostess, so they were air host stewards, and she had the same salary as a chief air hostess as an air host. So she was their chief, but she did not receive the salary, or not even close to the salary that her male peers received. And secondly, what happened in this Defren case, when she was going to go to pension, she had to go earlier than men that were working as air hosts had to go. So she challenged this case before the Belgian court. This is how it goes in the European Union in general, and I wanted to show you. This was Gabrielle Defren. She was an air hostess, and she wanted to know, because the EU, as we said at that time, it was, which year? I forgot, I think 1976, yeah. In 1976, it was the Treaty of Rome that was still in force. And what we did 5 minutes ago is the Treaty of Rome said equal pay for equal work. And she went before the Belgian court and said, in Article 119 of the Treaty of Rome, and Belgium was and is the part of the European community, it is said that me as a woman, I should be paid equally as my male colleagues. I want you, as my country, and which is a member state as well, to guarantee me this in the national legislation. And then she went to the Belgian court, as you see, national court, and it goes like this, just not to be confused. So she's here, she goes to the Belgian National Court. The National Court stops and says, okay, I'm not really clear with one question. Should I directly apply Article 119 in my national legislation? Does she have the right as an individual, as you and me, does she have a right to go before the court and says, I am not referring to my national law and national regulations, I'm referring to something higher. I'm referring to the treaty of the European communities. And it stopped and it asked questions to who? To the Court of Justice of the European Union. Court of Justice said the following. It said that, and we are here now, it says that men and women should receive equal pay for equal role. And it says EU is not merely an economic union, but we know in reality that it was, but never mind though. EU is not a merely economic union, but it is at the same time intended to ensure, as we talked about, social progress and have constant improvement of human rights. So meaning this principle, equal work for equal pay, should be directly applied in all member states and should be invoked by any individual that lives in the member state. So this is very important. This principle of equal pay for equal work is directly applicable. And this was decided by the European Court of Justice. And this was the first, I would say, a groundbreaking case that ensured the gender equality in some part of the EU policies. And what else it did, it actually initiated the first directive. So this equal treatment directive was actually the landmark directive that was introduced after this court case. And what it actually ensured was, and you have it here, that men and women should not only be treated equally when they work, and this is where we broaden the scope. They should be also treated equally when there is employment, where there is recruitment, training, promotions, and working conditions. So those are 5 things. Because some member states tended to, of course, do this. They hire more men than women, but then they give them the same conditions. But they continue to have a recruitment and hiring of men because they said equal work, equal pay. But then the directive was brought and said, okay, this principle of gender equality at work should not only be implemented when the women are hired. It should be implemented when we're discussing the first recruitment, when we're doing the first interviews, when we're actually doing the trainings, when women are actually doing this practice, internship, stars, or whatever they were doing, they should be treated equally. And then what actually was also a problem, men and women were paid equally, but only men were given promotions. And then what we have even today, you had more men who were in higher positions than women were. So this was the first directive after this Defren case, which introduced that not only equal pay for equal work and working conditions, but also promotions should endorse this principle that there should be equality among sex. So bear in mind that in the EU legislation until the 2000s, 2010s, it's always about the sex, not the gender. You all probably already discussed it. It's always discrimination based on sex, meaning that we have this kind of only men and women part. Only from 2010, or when we will talk about the Istanbul Convention, we talk about the gender. We'll see that later on.
Can I ask you something?
Yeah.
Just to check, in the EU law system, is it like in the common law with the precedents?
Yes, thank you for that question, which I will now tackle in a few minutes. As you read my mind, it is a quasi-precedent, meaning it is not stated that the Court of Justice decision should have primacy or should be implemented directly, but it stands in practice since the 50s that once the European Court of Justice have decided on something and have stated a principle or defined a principle, that should be applied in any other subsequent similar case. So it's called the system of quasi-precedents. It's similar to the common law. And there you have it. So here it is. Through its ruling, the Court of Justice effectively, of course, pressured, and it says that it is actually established any principle through the system of quasi-precedents, especially dealing with human rights, with values, with the rule of law, and of course with gender equality. And now I will just go through this. This is the role. Here it is. But I will go through this. These are the founding fathers of the European Union. Why do I show you this?
All men.
Yes. And they are the fathers. There was not a mother there. It's kind of a reverse biblical thing, where you have a Mary and there is no, I would say, a biological father. And here you only have a father with no mother, and they birthed European communities. Congratulations to them. And then they birthed it was a community. For me, community is a women. I don't know why, because it's a community. It was the first community was community of coal and steel. Again, I would always consider coal as I was a woman. And then afterwards is the European Economic Community, and then European Community on Atomic Energy. Atomic energy, of course, it's a female. I mean, it's atomic energy. So again, those were only founding fathers of the EU. And throughout decades, you will see in the European Union that only men dealt with anything dealing with the single market, core freedoms that we talked about, anything that was remotely connected to the development of the market liberties, etc., taxes, policies, etc. Those. And when you talk about the founding father, you always talk about Robert Schuman, you always talk about Jean Monnet, you all heard about them. And when the only women actually that appeared was in 1979. So bear in mind that the first European community was 2 decades ago founded. And in 1979, it was the first elections for the European Parliament where we had a direct election. So until 1979, those were the indirect elections. The first direct elections were in 1979, and the first woman that was elected to be the president was Simone Weil, and she was the first president and the first woman to appear in any, I would say, EU institution, not as a lead, but actually as a prominent name that existed. And this was the parliament. In the EU Commission, it was barely until the 90s. Only in 1989, as you can see, 2 women are appointed in the European Commission. Now you have a woman that is at the head of the European Commission. But you waited 4 decades for 2 women to become commissioners in the European Commission. So 2 decades for the Parliament and 4 decades for the European Commission. Why? Because the EU Parliament is like, I would say, an image of politics. So they wanted to have a better political image, so they put a woman. But the European Commission is something of a government of the European Union. So more hard work, meaning more papers, more policies, more, because the European Commission is the institution that proposes all legislation. And they thought for 4 decades that only men were capable to lead as commissioners all EU policies, starting from agriculture to coal and steel, up to everything else that they were dealing for capital services, goods, and even free movement of citizens. And then when the women were introduced as commissioners, those are women who became, interestingly enough, commissioner for taxes, and the other one who was commissioner for employment and social affairs, which was, I would say, very appropriate at the moment. The Simone Weil, she was actually a very famous French politician and French, I would say, writer and philosopher. And she dealt with a lot of gender equality issues as she could during her time, because the European Parliament, as I said, is a political body that could only adopt laws that were introduced and proposed by the Commission. The EU Parliament cannot itself, as is the case in the national legislation, it can only adopt resolutions. You all heard about the Parliament's resolutions, even in our everyday political life. So it's something that she did politically, not really legally. And then we go back here just to go with you through this. Name je sad ovo. Am I going back or forward? Ovo je sad nazad, jel da? Ni ja nemam pojma. Ovo smo prošla. Ne, nego sam išla na presjek. Da. This is what I wanted to go through with you. This is what you need to think when you think about the EU law. It's somewhat boring, I must tell you. If we don't do cases and we don't do practice, if I don't give you practical case, it will turn out to be just me talking about directives and articles and etc. So this is what you need to remember. There is one most important thing in the middle that is always primary law, and those are treaties and charter. So when we talk about the EU, firstly, treaty, secondly, charter. They are binding, they're applied in all member states, and they are considered to be foundational documents that all other are derived from. So any other piece of legislation should be harmonized and derived from primary law. Secondly, what we talk about is the Court of Justice case law. That is a quasi-precedent law and that influences a lot secondary law. So anything that was brought with the judgment could be later on brought in the secondary EU law. Do you know which pieces of legislation are secondary EU law? What can you name as a secondary EU law? Primary is a treaty, a charter. What should be a secondary law? Directive, okay. What else? Decision, yes. What else? The convention exists in the Council of Europe, and then there is one that is the regulation rights. Regulation. So the secondary law is regulation. Regulation, directive, decision. Those are the most important ones. Regulation is opinions, but opinions are not binding and mandatory. Regulation, and this is how you should remember it. Secondary law, regulation is binding in all member states and directly applied. Regulation. So binding in all member states and directly applied. Then you have directive, which is binding in all member states, but not applied directly. It is applied through adaptation and harmonization in the national legislation. It is implemented through national law. It only gives you, this is the easiest way you remember directive. The directive gives you the goal, and national legislation is the means how you're going to implement it. This is directive. So directive only gives the goal, and you're implementing it through national legislation. And the third one is decision. Decision is directed only to specific member state. So it could be, as we said in the beginning, it could be directed through Hungary, Poland, or maybe to 7 member states. And it is always directly applied. Those are the 3 types of secondary EU law that we are going to do on Wednesday. And it will be a somewhat boring course, but I'm very sorry, we need to go through it. And I will try to be as interested as possible, but we need to go through all secondary legislation. Why? Because primary law, that one in the middle, always give you only the founding principles, meaning gives you the basis. And then it is always developed and evolved through secondary EU law. So you always start from the foundation, the treaty, and then you develop it through decades, which is up to today, through secondary EU law. How do you think the general principles are birthed, I would say? How they are founded? Where can you find them? The general principles of EU law. Who is the one that introduces them, the general principles? What do you think?
Maybe that's the.
Who is the one that says, okay, gender equality is for example, is a basic principle of the EU? The court, yes. So here we go from this. This is the basics. The court introduces this, and then it is developed through this. This is the easiest way to remember. So this is the most important part, and this is our foundation. And I said, quasi-constitutional foundation. You should treat this as a constitution, EU constitution. And then you have the EU Court of Justice that develops principles, and then they're further developed through secondary EU law. This is how you remember it. And why do I mention here International and Court of Council of Europe law? Because one of the colleagues said, and I repeat it, member states of the European Union are at the same time members of Council of Europe. They're also members of United Nations, etc. So they also apply documents from other international organizations. Okay, and then what else I wanted before the break, I wanted you to remember. These are the bodies of the European Union, the institutions, in order not to confuse them with others. Why did I put this tree again as a triangle here? Catherine Ashton is not a politician anymore. She's a baroness from the Great Britain. Because this is how it goes in the EU. The European Commission proposes legislation. The European Commission is the official proposal and gives the official proposal to whom? To the Parliament and to the Council. They need to jointly actually give the decision and say, yes, we accept this proposal and we are going to make it a secondary EU legislation. So the secondary EU legislation starts from the proposal of the European Commission and should be adopted by these two. This is, as we call it, the institutional legislative triangle of the European Union. Why are these three here? Looks like an egg, like an Easter egg. Because above, the European Council should not be confused and confounded with the Council of the European Union. Why? EU Council, it only gives political guidelines. It is, as you see it on TV, for example, Macron and Merz and anybody else from the EU comes and have a meeting, and they say, for example, in 2026, our political goal of the European Union will be to reintroduce the sanctions to the Russian banks, for example. We're going to work more on gender equality. We're going to help, I don't know, Palestine. They're not going to help them, but they're going to say that they're going to stop the conflict, at least. So this is what the EU Council does. It gives political guidelines. And then, in that little framework, this three should work. Court of Justice, we did. And this European Court of Auditors is not really important for us, but Revizorski Sud, we're not going to do it, so you don't really care about it. So these are the EU institutions that you should know when you talk about the EU, and that I'm going to mention in the following, 2 weeks. That's why I need to just do them quickly. So we did this, and this is what I talked about. This is what you need to remember. I will put this PowerPoint presentation on Moodle so you can find it. Commission, so it proposes laws. Then it goes to the Parliament, then it goes to the Council of Ministers. And who oversees everything? Court of Justice. And this is actually the basic scheme that you will need to know about the EU in order to understand it. That's it. So I'm not going to ask you anymore, or you're not going to have anything else for the exam, or anything more than just the basics, okay? I think we're going to make a breakdown, and after we're going to start the new cases, and of course we're going to go to Treaty of Lisbon, which is the current treaty that exists in the European Union today, okay? Is that all right with you online?
It's okay.
Yes, okay. So we see each other in 15 minutes, okay?
Okay.
Okay.
Okay. I'm just going to, I'm just going to put Sorry for 6 minutes back. We have the enrollment of PhDs. So that's what I had as well. Okay. Okay, so we are going to continue. I'm not going to give you homework, don't worry. Did Boyana give you homework? Don't worry. I'm not going to give you homework.
About the mention,
Yeah.
we know that Boyana is delegates,
Yeah.
so she gave us a choice, but I don't know if the same exam we're talking about the same thing.
What did she say? Just to know for the exam.
That we have a choice between an essay and a regular oral.
And you are going to choose, I guess, essay.
We don't know yet.
You are still deciding, huh? Okay. Do you have for an essay? Should you pick a topic, or you should pick a topic?
But
Okay.
I imagine with her.
Yeah. Okay. No, you can if you pick an essay, you can pick an essay from any topic that was covered throughout the course, meaning from the International Council of Europe and European Union. You can do all three. I think for you, maybe I don't know how versed are you in writing? In writing, meaning have you written any kind of seminar papers or anything else? Did you?
Yeah, during the faculty, but long. So,
Okay.
Not really.
Not really. How about
Yeah.
Okay, I don't know because this is kind of a relevant question for your exam. Regarding the essay, what I think is the benefit of the essay is that it prepares you somewhat for your master I would say master paper or master thesis, because throughout the essay you'll see how to structure your paper, how to have proper referencing style, how to improve your referencing style, because I think you have practical work and you went through all how to use databases, how to do the referencing, etc. So if you pick an essay, with an essay, you're kind of doing kind of a mini preparation for the future written papers, and especially the end of your master, which will be the master thesis. So maybe that is, and also with an essay, you are kind of specialized only on one topic that you pick. While I think with the oral examination, I don't know, I'm not sure if she mentioned you're going to kind of have to set with variety of topics, I guess. Not the whole part, but I guess you will have to kind of do either international, either European, or something else. So this is kind of maybe we can go through that at the end of the course. I'll check with Bojana and see how the oral exam is done, because last year actually I was defending my thesis through a PhD thesis in France, and I was not here for the exam, and then the blockade started, and then we didn't have exams until I think July. So I will, if you want and if you are interested, I can check with other professors, and in the last class that we will have in this month, we can go through both options and see what fits you best. Okay?
That would be great. Yeah.
Okay.
That's fine, yeah.
It doesn't have to be EU law. Don't worry. If you pick something else, that's completely fine with me. Just my life led me to do the EU law, actually. So I started with human rights, but I ended up dealing with EU affairs. And that was all thanks to the Master of European Integration that we had. I was the first generation of the Master of European Integration. And then I became the intern, imagine, in the European Commission. So that's how I ended up eventually here. After a lot of work for government and non-governmental organizations. So you don't have to follow the EU step. You can go through international stream or even Council of Europe, European Court of Human Rights, whatever fits you best, I think. Okay. So we are going to continue for just this part of the introductory class. We're going to these are two very important cases, Kalanke and Marshall. So now you Google either one of them. You can Google Kalanke and Marshall just to see what was the point, because this is kind of what I told you about when the preferential treatment was given to women. And the court said, no, the women cannot have the preferential treatment in this case. So now the assignment for you, and it will last 2 minutes, is to Google what happened in the Kalanke judgment before the Court of Justice of the European Union. And then we'll go to the explanation. Have you read it? It's fine. I asked it. I asked ChatGPT a lot of things. The only thing that ChatGPT is not good, this is the only thing that I will tell you now while you're looking for the judgment. Last generation that we have for Law and Gender Master, we had, I think, 12 or 13 students. And among them, there were students who were from the law, political science, etc. But there were other students that were from the history or philology, etc. So when we have a legal clinic that you will be, I think, all participating in the second semester. And in the legal clinic, Professor Ivana Krstic and Bojana Tručković had actually divided the assignments, and we had groups. And they all had to write, and that's why I say the essay is a good thing. They had to write kind of a mini report or an essay on several topics. And we had I think we had Roma women. I did with 4 girls. I did for Roma women and the non-discrimination part. And one girl actually used ChatGPT for the whole report. This is kind of, you would say, okay, we would never do that. You can use artificial intelligence. I'm completely for that. I actually pay ChatGPT Pro. I even pay Jenny AI, which is kind of another artificial intelligence tool for academia. But what you cannot do with ChatGPT, and I will recognize it immediately, is that you give ChatGPT an assignment, write me an essay on that and that topic, because ChatGPT can never do from scratch. It can do what you did. I know the judgment, which is the most relevant judgment, so I figured it out myself through the research and everything else. Give me more details about that judgment. But he won't come up with that judgment if you give him from scratch. He will never go through every detail without your research first. So you can use artificial intelligence. I'm completely aware that you are not doing anything me too without the use of AI, but just don't give it to him as a complete assignment. Like you give it and say, okay, this is done. Firstly, you don't have adequate references. Secondly, I will definitely ask you, where did you get this from? How do you know this, etc. So this is the most important part. You first do your research. And then for deeper research, you can use ChatGPT, or maybe you can say, and I actually had a course on prompting, so I know you can ask ChatGPT, this is what I have so far. Could you help me to maybe elongate this part with some relevant information that you picked up from the institutions, etc. You have to give him a very, very strict guidelines. If you just say to him, as my candidate did, and I failed her, she said, just write to me about the Roma women in 2 pages and how they are discriminated in Europe. So it's very obvious. You would also see that ChatGPT wrote it, because ChatGPT, when writes, it gives you very, very nice decorative sentences that have no substance at all. And especially because we are at the Faculty of Law, where you need to have legal substance. I need to know what is the legal basis there. What are the treaties, for example? What is in the Council of Europe? And I need to know that. And if you just give me a perfect sentence in English, which I don't care about, this is not the faculty for philology, I don't really care for a sentence to be decorated perfectly. I just need to have legal and political basis. So use it, but use it wisely. And I can help you use it. It's not, we will actually introduce some courses dealing with the AI, because this is the ugly reality that we cannot do anything, basically, even cook, without ChatGPT. Okay, let's go. What happened with the Kalanke judgment? I'll ask first, did anyone online read the Kalanke judgment?
I've read the case. It's a landmark case in EU law where we set the limits for positive discrimination or affirmative action. A man who was passed over for promotion by a woman challenged the decision, because unconditionally preferring women in every situation in which there are both male and female candidates was viewed as taking things too far.
Okay, so the women was given an unconditional preferential treatment. What does it mean, an unconditional preferential treatment? This is just for thinking. It should not be written in the Court of Justice. Do you know maybe? What does it mean when you give somebody an unconditional preferential treatment?
Giving priority to, in this case, women or men, it can be, like giving the priority to them in choosing, when they're choosing
Yes. Yeah,
yeah,
it is
like-
priority. Do you think that they both, for example, in this case, they both had same qualifications? They did the same line of work, or they had similar CVs, biographies, or whatever. That means qualifications. What do you think? Did they have?
I believe they did, yes.
Yes. And then why do you think that this Kalanke was that man? It was his surname, Kalanke. What happened to this man? It happened that they both came from the same educational background. They both had same qualifications. When we say same, it's kind of similar when you weigh it substantially. And the preference was given to a woman because Bremen had a regulation, Bremen meaning a district in Germany, had a regulation when it says that women should be given priority when through employment. This is not a good example of regulation. Women should not be given an absolute priority because that is again reverse discrimination. Women should have, and this is the other case, Marshall, see that? Read this part. National rule that contains a saving clause is acceptable. What is a saving clause? Find it. You can ask ChatGPT if you want. What is a saving clause when we talk about gender equality? So first who finds it gets the grade. I'm kidding.
Is a legal provision in contract, statutes, or treaties that keeps other parts of the agreement or law effective even if one section is declared invalid.
This is in general saving clause, but you need to find it in saving clause in gender equality. Now you have to add another prompt or in Google. What is a saving clause? Did anyone find it online?
Allows the states to give or introduce special measures in order because of Netherlands
Dora?
represented.
Okay.
Decided that they might be.
This is what, okay, I understand what you want. This is saving clause. When you talk about saving clause, this is the definition of positive action. I think Alexander, when he read about the Kalanke judgment, he said that Kalanke judgment was something that introduced positive action. This means, this is positive action. What does it mean? What do you think that positive action in general means?
It's something that you do proactive.
Okay, positive action meaning being proactive, meaning endorsing gender equality, endorsing non-discrimination measures, etc., etc. So, saving clause is the best example of how to remember a saving clause. Quotas. Quota is a saving clause, I would say, because if in the parliament you have men and women which are and are to be elected, but in some countries, including ours, for the political parties, you have a certain number of binding quotas. So it means it saves a preferential treatment, which is not automatic. So it is based on objective assessment. And this is what is read here. It is acceptable if the male candidate is guaranteed an objective assessment which can override the priority, meaning that you don't give it an automatic priority. If, for example, you have women who are to be elected for the parliamentarians, but none of them, for example, have finished a faculty, and one of the conditions is to finish a higher education, you don't give them an automatic preferential treatment if the objective condition is not fulfilled. And that is what happened in this. This was considered in the academia a step back, this Kalanke and Marshall, because at one point you had this different case, you had this this kind of directive that was brought where you weren't only respecting the equal pay for equal work, but you are promoting treatment trainings, employment promotions. And then at one point you say, oh, no, men should not be, considered in a non-preferential position. We should be considering only through objective assessment. But it changed afterwards. I'll show you how, if I can move this mouse. Wait.
But Right, and they had similar background, they had.
Yeah.
Your biographies.
Yes.
You had make a choice.
Yes.
And then you have in that company, I don't know, I didn't remember what the company was, but you have a little number of women.
Yeah.
And that
It make it logical, but then they said it was given an automatic. It was automatic. It was not in this company. It was not considered in that way, as you said. It was automatically given to a woman without even considering a man. He was not even invited to an interview. It was automatically given to women due to a national rule. It was not a problem of that company. It was a problem of that national rule in Bremen that was given the automatic priority to a woman. It says you can give it, but you need to introduce the objective assessment at the beginning. That's what you said. You need to see everything that covers, so every bracket should be covered and checked until you can give a priority or meaning of preferential treatment to a woman. That was the problem. The national rule was the problem.
Do you know what happened with the woman who was elected to work?
Yeah.
She was she fired? And also, what would happen in this case if you have only one level of just one job interview, or just like your CV, and from the CV part, you are deciding to.
That's what they're doing from the CV. I would, for example, and that's what they're doing in the European Union. You never put the photo on your CV.
Yeah.
Because in that way, if the names are actually also covered, name and surname, so you are to be judged equally in that way. That woman actually stayed in her position. That woman that was, but Kalanke was given, I think, some kind of a reimbursement. I think, because what he did is actually he challenged the law. He did not challenge that company. And what the EU did, the EU said that the Bremen legislation is not according to the EU law, and they suspended the Bremen legislation. They did not interfere with the private company. That was what happened in that case. And if that was the case with only one interview, I need to think about what would happen if there was the case of just one interview. Do you think that it would be objective assessment?
It would be objective assessment.
I think it would be.
Only one level. She was then followed up with the after CV part, then the interview, and he was not the interview.
I would say it was an objective assessment. I can take it in my consideration. It would be an objective, and not because we are all women here, because I think if you have similar or same qualifications, then you need to go to a second stage, which is tête-à-tête, as the French would say, interview, where then who is best skilled? I mean, who has better skills in communications, in social skills, etc. And then I think this is completely objective. I think. Also, because if you're a lawyer, then you would think there is a way that you could prove that it was not objective. There is a way. He can prove, for example, that how many people, who were the commission, who was the jury? If there were more men in the jury, he could say that they gave preference to women because she was a woman, for example, if she was good looking. But this is again a prejudice. So this is very much you can never actually win, because then you would have a man who is actually saying that the, for example, male jury picked a woman because she was, for example, good looking.
Also, if women were in the jury,
or vice versa. You can say that men picked another man because he is their male peer and they think he is more competent. So you need to have really, then again, an objective assessment of those claims. Yeah, this is somebody from labor law who should explain that to you better. I mean, then going into those details of how you can estimate if there was a preferential treatment not based on objective assessment. And hopefully you'll have someone. I think you have labor law, right?
We have it,
but you didn't pick it, right? Did anybody pick the labor law? You did. Okay. Anybody else? Yeah, nobody. Okay. So you'll have the chance to learn more about it. Okay. So I'll go to the part where this is the part what I need. By the way, Maastricht Treaty. I'm not going to dwell into it. I'm just going to mention one thing. Before this Equal Treatment Directive, this was during the European communities. So the European Union did not exist. Afterwards, wait, I'm going to go back. The first treaty that introduced the European Union was the Maastricht Treaty. This you should know. When did it happen? Do you know? Yeah, it was written. 1992 actually came into force in 1993. And what happened is that this Treaty of Maastricht actually united these three communities into one union. And this is, and maybe this is important for you to remember, just like as general knowledge, this is when the politicization of the union started. So up to this point, for 4 decades, we talked about the economic goals. From this point onwards, you have, of course, economy, but you have political union. Why do I tell you about it? Because one of the most important political goals was actually introduced only a few years after, and that was with the Treaty of Amsterdam. Treaty of Amsterdam was actually enforced in 1997, so only 4 years after, and for the first time, it introduces articles that are directly dealing with discrimination, gender or sex discrimination, and equality between men and women. And as I already promised, you will have everything on Moodle, and I actually underlined it as a good geek I did underline which were the most important provisions that you need to know from the Amsterdam Treaty. So what is here important? Firstly, this is Article 13, which of course enforces that the Council should take action to combat discrimination. Secondly, look at this second part, amendment of Article 2. It says, the list of tasks facing the Commission, meaning the European Commission, will include the promotion of equality between men and women. This is again gender mainstreaming. So meaning that not only member states, and this is important, not only member states are obliged to implement all legislation that is dealing with gender discrimination, but also EU institutions are equally obliged to promote that and to implement it in any kind of policy that they're dealing with, meaning economy, but also politics. And fast forward, we will do in the next class, but this is important. See how many directives were brought after the Amsterdam Treaty, and they were all dealing with gender, meaning discrimination on religion, age, sexual orientation. First time we have sexual orientation. Secondly, sex equality in employment. Thirdly, access to goods and services. This was also important. So this we will do on Wednesday. I just wanted to underline that after this Amsterdam Treaty, so after the basis was changed, the basis was strengthened. Now you have so many more pieces of legislation in the secondary legislation. And we come to the last one. This is Treaty of Lisbon. This is treaty that is still in force in the European Union. And when I talk about it still in force, because it should not be enforced, because the European Union is completely changed from the European Union from 2009. So this is something that is kind of, when you have a picture that is bigger than the framework, the frame that you have. This is the state of affairs in the European Union. But we have it now, and we now have to analyze what we have at the moment. And this is what we have. So the Treaty of Lisbon is composed of 2 treaties. Have you heard about them? Do you know what is this TEU and TPO?
F is for function.
Yes. The TEU, the F is for functioning. This is great. TEU is Treaty on the European Union, the first one, and the second one is Treaty on the Functioning of the European Union. And how I remember them, they are like, you know, when you were in elementary school, you had a book and you had like a working or radna sveska. So you had a book, it's like a bukvar, and then you have a radna sveska, which is a working book. TEU is bukvar, meaning this is everything you need to know, one-on-one, the basis. Treaty on the European Union. And Treaty on the Functioning of the European Union, and this F is the motive. This is how the EU functions. So in the Treaty on the European Union, it gives you the basis. And in the functioning, it gives you how you will implement and how it functions in practice. The Treaty on the European Union has, I think, 30 pages. The Treaty on the Functioning of the European Union has more than 200 pages. This is the working book and the book. of the European Union. And this is, in general, in global, called Treaty of Lisbon. So Treaty of Lisbon, and this is very important for you to know as a general knowledge, is consisted of two treaties, EU and TFEU. So the most important article that you need to know about is Article 2. And why do I mention Article 2? Because that is the article that every politician in the European Union starts from. Everything you, for example, if you watch Ursula von der Leyen when she talks about Serbia, when you read about the progress report on Serbia in 2024 and 2025, etc., it always starts with Serbia is a candidate country that should respect the values of the European Union that are enshrined in the Article 2 of the European Union. And I wrote a PhD about it. It has 600 pages, so you can read about it. Never. I did actually write about every value that the EU has. And the problem with those values is, and I'll tell you from practice, is how you understand each value. So if we say the EU is founded on the values, and then you give human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, how do you understand rule of law? I don't think that each member state understands the rule of law in the same manner.
But that's also why we don't have a definition of human rights.
Yes, and that is also kind of problematic when you start from the Article 2. As they say in the EU, Article 2 is a constitutional basis, quasi-constitutional basis for the functioning of the European Union. And then you have countries that understands and implement completely differently each value that is written here. But why we learn it here is because Article 2, and now we'll look at the second sentence, these values are common to the member state in a society, and now we define the society in which pluralism, non-discrimination, and blah, 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 tolerance, and equality between men and women prevail. And if you have an exam, for example, and somebody asks you, how is gender equality regulated in the European Union? You always start from Article 2. You will never make a mistake, and it will be great because you'll probably know better than your teacher if it's somebody else, except the three of us. So it's, EU has a constitutional basis, we say quasi-constitutional, in Article 2, and Article 2 in its second paragraph, this is the one that is bold, has and guarantees, firstly, non-discrimination, and secondly, equality between men and women. Again, it's not said gender equality, it said men and women. Then we go to Article 3. Article 3 is the Union, again, we see what is the prevailing goal of the EU. It's always single market, internal market. But again, we look at this bold part. It shall combat social exclusion, again, and discrimination, and shall promote social justice protection, again, and equality between men and women. So in the Article 2 is the obligation for all. So meaning obligation for EU member states and obligation for EU institutions. Article 3 is the obligation only for the EU to promote. This is gender mainstreaming. And then we go to the functioning of the EU. It's Article 157, and that is the article that is the long-standing article taken from the Treaty of Rome, and that is the principle equal pay, but here is differently, for male and female workers for equal work, and look at this, work of equal value. What does it mean? What is the difference between equal work or work of equal value? What do you think? Is there a difference, or how would you define that difference?
I would say if you do exactly the same type of work, same type of science, the work that's an equal work. But this equal value is for me something more subjective, like someone else is to say this is more valuable than what you do, and it's the first one is more like an objective measure, and this one more like to say
yes,
what you do is more important.
Yes, thank you. What do you think? Does anybody else has anything else to add? But I would agree with you. What is the work? Do you have an example for work of equal value, for example? What would be the work of equal value? They don't. And they were so active at the first part. I had
You're just thinking.
you're thinking. Okay, while you're thinking, I'll give you an example. I had a discussion with a colleague of mine, and those of you from Serbia will know him. It's the colleague of mine who is called Miloš Jovanović, and he's a politician as well, and also because I'm his closest colleague here, because he's also assistant professor, and he thought that, and I will ask you, what do you think, that men and women in tennis should not have the equal prize money in competitions. So you have those four.
What was his argument for that?
Yeah, what was his argument? His argument, I'll tell you, because I had an argument with him, so I know his argument. His argument was that men tennis is in every category more attractive than women tennis, meaning that men tennis, men categories attract more sponsors, more audience, more people, more television rights, more commercial rights, etc. And therefore, having in mind that they all attract more of those factors, there should be rewarded more. What do you think about that? Yes.
Oh, I heard that argument before from some persons, male persons, but it was regarding football. But
Okay.
yeah, I don't agree with that.
But here in tennis, it's very specific, because if you look at it, before the three musketeers that we have now, firstly with Novak Djokovic and then with Nadal and Federer, actually women tennis was equally really regarded and attractive in their own categories as male tennis. I think you all know female tennis players that are, I would say, equally popular, equally attractive, not in a sexual sense, but in a very attractive, meaning all the categories he has given me. I think I don't think that there is a rationale for having a different prize money, because we all have physical boundaries, meaning that men go up to their physical boundaries and women go up to theirs. Even, I think, Serena Williams has, for example, a stronger service than any other male, except I think Wawrinka or somebody else. So I don't even think that like masculinity or force or anything else should be in game. But if you have any other opinion, I can take it. I mean, I actually listened to him very carefully, but this is kind of, is it equal work? This was my question. Do you think that in tennis, if we look at the finale of Australian Open for men and women, is it work, equal work? Yes.
Yes.
What do you say? Yes. Anybody else? Well, I would say they all agree. If they don't say they don't agree, then if they disagree, then I would equal work. Do you think that when women play an Australian Open of 5 hours and men as well, do you think that it's equal
Yes,
work?
I mean, they're playing the same sport, doing the same moves and the same amount of time and the same amount of time for the practice and preparation. So I don't see a difference there.
Professor, if I add something.
Yes, you can. Maybe you have.
Right, so it's quite funny you mentioned tennis, and there's a somewhat famous quote by tennis player Rafael Nadal on this exact topic. He was asked why male tennis players earn more than female, and he asked the interviewer.
Ne, prekide se. Wait. Yo, prekio se, Aleksandar.
Sorry, can you hear me?
Alexandre, you were interrupted by internet. So let me go again. Nadal was asked, what does he think?
Right, so during an interview, tennis player Rafael Nadal was asked why male tennis players earn more money than female tennis players.
Okay.
And he responded by asking the interviewer why female models earn more than male models. I think a common argument in this situation is supply and demand. Certain professions earn more money because they attract a certain gender more, and people have more interest in watching male tennis.
But again,
It's usually explained away by saying men are more skilled, it's a higher level of play, they earn more sponsorship money.
Are they skilled? Are they more skilled? The thing is, are they? I mean, for football, I could agree to some extent, having in mind that FIFA really attracts more audience, bigger crowd, and everything else. But for example, for tennis, I do not think that in a certain level that is kind of true. This male-female models. Yes.
This is the same sport.
Yeah.
And why should the woman be paid less because of being less attractive? I mean,
but demand supply, as we say.
Yeah. Same thing. And it's not her fault because other people just don't enjoy it. I mean,
they don't think that it is the same attractiveness, meaning as, the efforts giving and everything else. Yeah.
But I think that can't go without the conversation about why is a male version of a sport and example more attractive or more popular or more attractive for donors and sponsorships. I don't think that the answer lies in who is capable more, women tennis players or male tennis players.
Why do you think it's more attractive for sponsors, for example?
Because I think male versions of sport are more popular than women,
and that's
because different. Because I think maybe that's a preference of mine, but men more follow sport than women.
Because that's from history.
That's also,
and I don't know when was actually given for a woman to play football. So tennis was okay for a sport for women to play. But for football, so you have a long tradition of only men playing one sport and other sports as well.
And they are, and the tennis players, that was again a story about when you look at the female tennis players, they are overly sexualized even in commercial, even in what they were wearing and everything else. Yeah.
Can I tell you a short story about football and AI? Related to this topic that we are speaking of. So in my previous organization, we were dealing with the media information literacy. So we were also dealing with the AI when the AI showed. So it was really some basic, not ChatGPT, but some basic and the old versions of AI. And we asked them, asked it a question, who has the most goals? I don't know if it said in English goal like in football. You know what I mean? Mm-hmm. Core, or how to say. So the AI said some name, I forgot the name, but it was a male football player. And then we did the fact checking, and then we saw that actually a female football player has the most scores in football, but the AI didn't recognize her and said the name of a male football player. So I would say that also the marketing and the AI and the internet and everything is working against women in that sense because of the profit and because of the money which they can earn. So they saw the opportunity to boost the male sports more. So I also see a reason in that.
I think this was a kind of an example as well. Thank you for an automatic, response, because I think the ChatGPT is kind of, or when you mention a football player, he automatically thinks it's a male football player. And that is how you prompt it. And probably somebody who prompted the ChatGPT or any other artificial intelligence did that way, that the ChatGPT immediately thinks of a male football player. I definitely think that's the reason, but thank you for that example. Unfortunately, I have to go on furthermore to mention this charter, which Alexandra at the beginning mentioned as well. The second thing, after these two treaties, actually after the Treaty of Lisbon that encompasses both, the second thing that you must know, and for example, you get the exam question about the EU, you first mentioned this Treaty of the EU and Treaty on the Functioning, and immediately after you should mention the Charter of Fundamental Rights. Why is this charter important? Because this was the first document that dealt with fundamental or human rights in the EU. This was the first document that was not oriented towards economic goals, towards any other single market, I would say motivated outcome, but it was a document that is and is still today the same legal value as the Treaty of the European Union, meaning they're the same at the same basis, like primary law. So primary is Treaty on the European Union, Treaty on the Functioning, and the Charter. And the Charter is kind of, I would say, kind of how we say pandan, kind of, tako pandan Evropskoj konvenciji. Do I need a better word? It's not a double, but it's kind of something as a rival to the EU Convention of Human Rights. So it's something that the EU, as I mentioned to you, becoming a political union, it realized that it needed something to be more founded on political goals, and one of the most important political goals was and still is the protection of fundamental rights. And bear in mind that here, see, the title is fundamental, not human rights, meaning that still European Union thinks in a more broader sense, and it differentiates itself from the Council of Europe and from the European Court of Human Rights. And these are the chapters here in the picture, if you can see it. The most important chapter that you should mention is chapter 3, equality. And here we are at the chapter 3, equality. I will mention to you, the most important 3 articles that you have to know. Article 21, first one. This is all under the chapter 3. Article 21 is the chapter that lays down non-discrimination rules. So it does not only deals with sex, but also race, color, social background, ethnic background, and other features. Secondly, Article 23. This is the prohibition of equality, what we mentioned in the quiz. So in the first one is prohibition of discrimination. The second one is equality between men and women. And this Article 23 is the most important one. This one, equality between men and women, must be ensured. And here we are, for the first time, it is said in all areas. So it is not only equal work, equal pay, but in all areas. And also, due to the Court of Justice and all the practice that we did, meaning the judgments, look at the second sentence. The principle of equality shall not prevent the maintenance or adoption of measures providing for specific advantages in favor of underrepresented sex. And this is due to all the judgments that we did. Then, what is it called? It's called positive action. And I wrote it here so you don't have to think about it. This giving a specific advantage to underrepresented sex, it's called affirmative or positive action. Then what it also introduces, and what I think I asked you in the quiz, what do you think that EU gave preferential treatment to? Family life. So it's again related to work, and read it, Article 33. To reconcile family and professional life, everyone shall have the right to protection from dismissal for reasons connected to maternity, and the right to paid maternity. So those are 2 rights, and a parental leave. You'll have it, don't worry, in your, I'll just attach it to Moodle. Why do I mention this final Article 51? And this is trickiest part. This all is guaranteed in the EU and the member states, but only when implementing EU law. So if it doesn't deal, if, for example, if you have national legislation that is not connected to the EU law, that is not implementing EU law, you don't have a legal standing. So look carefully at the Article 51, and this is the trickiest part when you have to go before the Court of Justice of the European Union, and they ask you, what is your legal basis? And you say, for example, I have been discriminated against. They ask you on which article. You say Article 21, for example, based on sex and race. It's kind of intersectional discrimination. And then they say, but when did it happen? How did it happen? And here is the most important part. You must make a connection that this discrimination particularly happens when, for example, your employer or your state implemented or was dealing with EU law. If it falls outside of the competence of EU law, you cannot call upon charter. You cannot deal with the EU. So this Article 51 is kind of something, it's kind of a field of application. I can protect my own rights, and I can rely on the charter and on the treaties and everything else, but only if it falls within the scope of the EU. Let me give you an example. Criminal system of each state. Does it fall under the EU? No, something really, really tiny. You know what it falls? For example, sexual violence, human trafficking, cooperation between the courts, and you know what else? European arrest warrant. It falls within the scope of the EU. Everything else dealing with criminal matters is outside of the EU scope. So you cannot rely on the charter if it's not implementing on or dealing with the EU rights, which are guaranteed under the EU law. And that's why I mentioned this last article. It's not something that guarantees the prohibition of gender discrimination. It's something that you have to know, that if you deal with gender and if you want to have gender equality, you have to know in which field you are implementing it or relying it if you're going before the Court of Justice of the Human Rights. This is something for you to know. I made you kind of a short summary of the most important things that you have to know. What is the founding value? What is the aim of the Union? Which are the general principles? And what can you do with the Charter? Also this, if somebody, for example, at the exam asks you why is the Charter important, 3 things you can mention it. This is kind of for me doing like a short schemes for you to think about it if you're preparing for an exam. You'll have it on Moodle. And the last thing that I will just show you for today, this is today's European Court of Justice. So it kind of is different because before you didn't even have any women who were either just justices, as they say, or judges, or advocat general. Do you know what an advocat general is in the court? Nije kao pravobranilac, nego tako se zove, ali ne radi to što radi opšti pravobranilac.
Is it like a practice?
No, this is kind of a very specific thing that exists in Court of Justice of the EU. This is what I ask my students in the first year, and they never get it because it's kind of specific, really. Does anybody knows what the advocat general does? I guess no. I'll tell you.
No.
Yeah, somebody knows. Tell me.
No, I said no.
No. Okay. Even better. I'll explain it. So, when there is a case before the Court of Justice of the European Union, either before an ordinary chamber or a grand chamber, it just depends on the number of the judges and the importance of the case. You have always 1 or 2 advocate general appointed. Those guys are actually more relevant than the judges because they're the ones who actually go through whole case, through case law, through everything, through legal argumentation, and give their own opinion. After they give the opinion on the case and the analysis of the whole legislation, not only EU legislation, but national legislation, they deliver that opinion to the chamber. And then the chamber has the right to either agrees with the opinion or disagrees with the opinion and takes only some parts that they're convenient with. Advocate General is always in the EU law known by his or her name, and judges are in the chamber. You always know that the decision was brought by chamber number 1, 3, or grand chamber, and it included Advocate General Medina, for example, or Tamara Čapeta from Croatia, because Advocate Generals are more important players than the judges. They're the ones who are personally delivering their whole analysis and opinion, and the court is the one that either will, I would say, accept it, which they do in the majority of cases, semi-accept it, they agree to somewhat extension, or they would say, oh, well, okay, we don't agree, we disagree with, which is rarely an occasion. And I'll give you now the stats, what is now in the Court of Justice. Yes.
Then the advocate general
dismiss the.
No, it only gives the opinion. It never dismisses the case. It gives you the facts, it gives you what he would do, but he never dismisses the case. The dismissal goes before the court. The judges do the dismissal. The Advocate General is kind of, you know what it does? It's got kind of a legal triage. It gives a thorough legal analysis. It starts, as we all said, from the basis, starts from the treaties, it goes to the tiniest little detail in the EU, and then it goes, okay, which is the opponent state, for example, Hungary, then it analyzes everything in Hungary. Then what the Advocate General also does, he analyzes previous case law in Hungary, for example, and previous case law in the EU. It gives the summary of everything. And when we say Advocate General, it has the whole office before. You can work for the Advocate General for years and years. Kao opšti pravobranilac in some way, but it's not defending anyone.
So you can say, for example, under the Article 51, that this is not for this court.
It can say, but it would be somebody before the Advocate General. Advocate General is included after you consider the dismissal or not.
Okay.
You then go into meritum, and then Advocate General is included afterwards. So it doesn't dismiss. It deals with substance of law. So that's the Advocate General. That's maybe the closest definition of what the Advocate General does, dealing and with an analysis in the substance of EU law. And this is kind of the stat for the judges. So the third paragraph is very important. In its current composition, the Court of Justice has the highest number for now, female representative, meaning 6 out of 27 judges. Before it was 2 or 1, and before the 90s, there was never a female judge. So I think the first judge, let me get, is only 12, of whom 11% were women until today. Only 11%. And I think today we have Advocate General, only 7% of women. So 6% of judges and 7% of women for the Advocate General. And for example, what is very important, when you're dealing with EU law, writing in EU law, the last sentence, they are, and then they say, Julian Kokot and Tamara Chapet and Laila Medina. Those persons were so important for the EU evolution. For example, this Julian Kokot, I think I referenced it her, not dealing with gender. She was dealing with everything. She was dealing with competencies, with taxes, with everything. She was so lucrative and so hardworking. And I think at that time, she was the only female Advocate General, and since 2003. And she still stayed on her function. But as you can see, even though EU strives, and we will deal with it in the next class, to have a gender equality, when it comes to their most important, I would say the only court that they have 6%. I mean, 22 of 6 out of 27 women. And this is the other court, because the Court of Justice of the European Union also has a general court. The general court deals with competition cases, for example. This is the most important part, but it also deals with other things. But competition is number one priority. And for example, as you can see, there are 80 women among 54 judges. So it's 33%. That is kind of very high and it gives a tendency that this number is going to grow. See the last part. Countries like Belgium, then Greece, Hungary, Lithuania, and Luxembourg have never appointed women. Because my follow-up question is, why the women are not elected to be judges of the Court of Justice of the European Union? Because the election depends on their national states. It has to be a national state that nominates you to become a judge of the Court of Justice. So if there is nobody in the member state that wants to endorse a woman, either for a general court or Court of Justice, or even to be an Advocate General, then you cannot impose it as the European Union, saying, oh, in Hungary, I want particularly that woman to come. So it should be Hungary that nominates the woman. And Hungary actually never nominated a woman for Advocate General, a woman for the Parliament, a woman for I think as well for the Commission. I think rarely they nominate women for the leading positions. And this is the fact for the EU institutions. You will have it. So maybe what I will draw your attention to currently, the best number that they ever had is closely to 40% of the members of the parliament that are women. And as you know, now you have a president, which is a woman, and 8 out of 14, 14 vice presidents, which is the EU Parliament. And let me show you the Commission.
Is there any quota for European Parliament like we have it in Serbia?
No, unfortunately, there is no quota because of the member states. So some member states, and this is important, some member states have quotas for their own propositions for the EU Parliament, but EU cannot impose a general quota because member states are the ones that nominate. But for example, if you have Lithuania or, I don't know, Luxembourg that never nominates, so here you are. In some aspects, there are quotas, and on the third class, we're going to deal with positive action and quotas, but not in every. But this is the best situation that they had so far. As you see, from the beginning, it had only 15% up to 40% now. Let me just find the Commission. Yeah, Commission is now, you have Ursula von der Leyen, which is kind of the first president. And because of her, now we have this EU gender equality strategy that we will deal with. And because of her, there is kind of a 50-50 gender balanced approach to the EU Commission work. So maybe Commission and Parliament are the best standing institutions of the EU. And there is the last question that I have for you for today, as I am respecting it. Oh no, 6 minutes later. What is the EU gender gap? What do you think that you know what the gender gap is? So what do you think that the number that the best represent the EU gender gap? What do you think that the number is? Okay. Somewhere in the middle, you will say B. What else? Does anybody else have another opinion? Okay, I'll give you the answer now. It's all. So for each category, there is a gender gap, and we'll deal with it. That's why all those directives were brought to deal with the gender gap in different spheres, competences, and aspects. Firstly, a gender pay gap. Secondly, pension gap, which we talked about. And then overall, which is the most problematic one, overall earnings gap, because there are self-employed women, and then we recognize them, but then the self-employed men, and then again we have women, which we'll talk about, which went to maternity leave, which are working half-time, men and women which take parental leaves, etc., for taking care of a child which is ill, etc., etc. So
that's the statistic for the EU member states.
Yeah, only for EU member states.
Okay.
It's not candidate countries. I didn't actually take overall earning gap was this is for 2018. This is kind of slightly changed. I think it's 32% now. So this is kind of slightly changed, but these two were not changed: the gender pay gap and gender pension gap. So in every aspect at which we are going to deal with now, there is a gender gap. So this is kind of for the end. And you'll see it's why. See, for example, this is from 2024. So 15.7 gender pay gap in 24, 30 is now gender pay. So it was 25.4 in 2023, 30.1 in 2024. Then there is also gender equality that should be in corporate boards, CEOs of private companies, etc., etc. But this we will deal in the EU secondary legislation. Okay? I will not bother you with this. This is for you because I mentioned the EU Gender Equality Index, because this will be important for you if you're going to deal, for example, in the legal clinics and whatever. You will need the stats and data. And I gave you here all the links that you need. Okay? Okay. Do you have any questions? Are you alive? That's also very important.
Yeah,
yes.
Professor Kav.
Yeah.
Wala Puno.
Yes, thank you for the lecture.
Okay, I hope it was somewhat interesting.
It was really interesting.
Thank you. Thank you. If you have any questions, you are free. I'll give you my email after the lecture, so you also have my email as well, and I'll send you the PowerPoint presentation, and also I will send you some materials for the next class. But as I'm not optimistic, I know that you will not read them all before the lecture, but I have to send you because, that's kind of what I have to do as a professor. So any questions you have or any help that you need, you can write to me on my email. I'm very at your disposition, okay?
Okay.
Thank
Okay.
you so much and have a lovely weekend. Don't study anymore. I don't think that weekend is just for work and study.
We need to do our homework now.
Well, you won't have homework from me, but good luck. Bye. Bye.
Bye. Thank you.